So just one thing on one of the last parashas here. So I can't quote the name. I looked at it a few days, well, a few days before I left. It said that Moshe was talking to the Jewish people, and he knew that we weren't going to be perfect in the future, and we people would 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 uh, would sin and wouldn't be perfect. He knew it, and he actually said so. So unfortunately, I can't find the place. So at the end of the day, we're not perfect, and we have to try our best to do the good wherever possible. And But they knew that perfection wouldn't be possible with some people, not all. Some people, as we know, all of us know, there are tzaddikim in whatever Joburg, whatever community who are what do you call squeaky clean and are like Snow White, or and are almost sin free, so to speak, or complete. I know some people, and it's mentioned, but these people are like tzaddikim. So it does exist, but uh, not easy to find such not easy to find such people, but they do exist.
Okay.
So they say it's 1 in 4, so it's one of us.
Who
That's
Oh,
just a
is?
really?
joke. It's a joke. I just made that up.
I
All
thought
right.
it was 1 in 5,
Next.
and then it's none of us. No, I'm kidding.
Yeah, it probably is 1 in 5. That's why we have a problem. That was a good one. Nice counter there. Very good.
Damon, it's look to your left, look to your right, look down. It's one of you.
Yeah, that's true. That's true. All right. Guys, we're doing obviously a new aspect in the Mishnah, but it's actually what was discussed on Tuesday. So we learned in our Mishnah and in the Brisa we stated last time that one who consumes property which was stolen by someone else is not obligated to reimburse the owner. Okay? Because we learned in the Brisa that the rabbis taught that the Torah states in Leviticus Vayikra chapter 5 verse 23, you remember that pasuk, and he shall return the robbed article that he robbed. So it's superfluous. Why can't you just say he returned the robbed article or returned the article that he robbed? It's the double word robbed that has an issue. So why does it repeat itself? We know nothing is superfluous in the Torah or unnecessary. It means that he shall return the stolen article as it was when he robbed it. Okay? And what does that imply? That if it is no longer in that same state, it doesn't constitute the return of that particular article, but only that at the end of the day, the cash equivalent is paid by the first party, the robber. We're not talking about a third party that consumes. So we said if the article has a physical change, it no longer resembles that which he stole, and therefore has to give the cash equivalent. So if it's a change of the physical features, we also learned that a change of behavior of the person that owned it from really holding onto the article with all his heart to almost giving it up. When he gives up hope of returning, having the article returned to him, that yush, that despair, almost releases its hold on the object to a certain extent, but it has to be combined with the change of domain. And those two aspects constitute that the robber would have to give the cash equivalent. Now, it's not that he gets to keep it. We're talking about a third party here. So one of the things we learn about a third party is that if the robbed article is no longer in existence, is entirely exempt from liability, the third party, and need not even pay its monetary value. So it obviously doesn't apply to the robber itself because he's got to pay for an object even if it's not in existence. So it has to apply to one of his sons or any other third party who consumed the robbed article, according to Rashi. So what did we learn about Rav Chisda? I'm not going to test you guys. He limits the exemption to where the sons consumed the article after the owner reached the stage of Yu'ush, while Rami Bar Kamma applies it even when they consumed the article before Yu'ush, because it's a third party. So we learned that based on what the sages say, if one robs something and feeds it to his children, they're not liable to pay the owner for it because the article no longer exists and they were not the ones who stole it. If he left the stolen article before them intact as an inheritance, whether they are adults or minors, they are liable to return it. Because obviously, guys, if the article still exists, even the robber's children or other third party are obligated to return it. Now, what did we learn in the name of Sumchus, who said if the heirs are adults, they are liable to return the intact article, but if they are minors, they are not liable to return it. Now, we're going to obviously see why that is. But if you could take a guess, what would you think the reason is?
Repeat the question, please.
Okay.
Yeah, I am listening. Just repeat the question.
Basically, you've got a robber. If his children are adults and inherited the robbed property and it hasn't been consumed yet, say inherited food and it wasn't consumed, the adults have to return it if it's intact. The children do not of the heirs. Why do you think the children or minors do not?
Obviously, because they're minors. That's obviously the obvious reason.
Yes.
Pekuach nefesh.
No,
To be
Kevin's
fed.
right. But just to explain it further, is that minors can't be prosecuted. So although the minors should return it, if there's no legal recourse, how are you going to extract it from them? You couldn't just go
legal capacity.
You couldn't just slap the latte as much as you want to. And Kevin's right on a different level is that I suppose there's more rachamim because children can't really earn themselves. I like that actually.
Well,
So
that's what I was thinking actually, more in those lines, not in the lines that you were saying. Actually,
Yeah,
what Kevin was thinking.
correct.
I didn't express it,
like,
but that's what I was thinking as well. It
I
is a
like
better
what,
answer. Wow.
I like what Kevin's saying, but the Gemara likes what you say.
It.
Yeah. So just go with
Yeah,
what
it's
you
a bit
say.
of both. I was thinking of both. Yeah.
Okay.
All right. Well, I guess they're both good answers.
In this case, it's a legal case, so it's not about compassion because things should be returned even if you're not obligated to do so. This is a case of legal extraction. All right, so guys, the Gemara cites an incident where the preceding dispute applies. So the minor son of Rav Yirmiyah, his I tell you what. Before we get to this whole case, let's just deal with another version of Rami Bar Kamma's statement because you're going to get a little bit lost, okay? Because I think you're missing some of the ground rules. So I'm just going to go to different reference points, and then it's going to help you guys. I should have brought those reference points further, but I'm just going to reiterate them. Rami Bar Kamma inferred from our Mishnah that inheritance constitutes a change of domain, as if the robber sold the stolen property to a purchaser, right? So the Gemara presents a different version of Rami Bar Kamma's statement, according to which he draws his inference not from our Mishnah but from a brisa. Rav Adar Bar Ahava teaches the statement of Rami Bar Kamma in reference to the following brisa. If their father died and left them money that was an interest payment for a loan. Okay, now we're talking about the connection with robbery and a loan, and you're going to see where it comes into play here. So, Kevin, in this case, Rami Bar Kamma is talking about if a father died and left money that was an interest payment for a loan, even though they know that it's interest, they're not obligated to return it. In other words, if you look at Leviticus chapter 25, verse 36, Vayikra, the Torah commands one who lends money to another Jew, and it says the following: do not take interest from him and increase, but you shall fear your God, so that your brother may live with you. So when you guys a reference point to Bava Kamma 62 Aleph, what it does is it expounds that concluding clause, and it says, so that your brother may live with you. So what does that mean? It means as a commandment to refund any interest taking. Why? Because that facilitates the borrower's economic survival. So there's two aspects to it. One is if you're living next to somebody that's really taking advantage of a bad situation, it's certainly not going to be really that livable. But it's using this term literally, may live with you, meaning if you actually cripple him financially, his economic survival equates to his actual survival. So therefore, you cannot take any interest against a fellow Jew because you're half crippling his survival mechanisms. So the Torah teaches that the lender, that although the lender has to refund the interest payment, should he die, without doing so, his heirs may keep the money and do not have to return it. Okay, why? Because if the Torah says shall live with you, okay, it means with the robber. If he shall live with you, be amongst you. It doesn't say you and your children. So it doesn't extend to the heirs themselves, okay? So what does this mean? Rami Bava Kamma said that this teaches that the domain of an heir is similar to the domain of a purchaser. When one leaves property to his heirs, it undergoes a change of domain, just as it would if he were to sell it to a purchaser. So by virtue of this dint of locale, so to speak, okay, then this change of domain in combination with Yush means that the heirs are not responsible. So it was the same as if the lender then took the assets to sell it to a purchaser. Okay, so by virtue of this change, the heirs of a man who lent on interest acquire the illegal payment. So what we're saying is actually they acquire it through a combination of Yush and a change of domain. How do we know this? All right, guys, I want to ask you something. If you borrow money from Chester Finance, okay, and they're Jews, okay, just what happens in Vegas stays in Vegas.
This is on YouTube. It's not just Vegas.
Chester is a town in Wales, actually, Damon. What stays in Wales? Okay.
Yeah. So what we are saying is
the Welsh company, yes.
What we are saying is follows: when you borrow money and they have interest, you immediately go through almost this yush, which is a despair of recovering the interest. Why? Because you're agreeing to their payment terms. You might not like it, but you have to take it because you need the money. So if they're charging an interest and you go ahead and accept the money, it's on the agreement that you are prepared to pay back the interest, and therefore you've consented. Albeit grudgingly, you still consented legally. And therefore, what that means is that you've had Yush at that point. What is Yush, Gavin?
Despair.
Despair of what? Is it depression?
What is despair of not that type of, well, yes, depression too, but due to you never being able to recover your object again or your lost article.
Exactly. So what we are saying is here, although interest is a form of robbery, it's different to when somebody steals the article against your will. You never legally signed to agree to that. Here, although you despair of ever getting back the interest, because you know that's where the loan sharks earn their money. The reality is you despaired of recovering that interest because you know they're not doing it just to help you. They're doing it for their interest, no pun and therefore you despair of getting back that fee of blood money that you were charged. So that Yush has already taken place by dint of you signing the agreement already. And therefore, Yush has taken place legally anyway. Kevin asked, how do you know Yush has taken place? You agree to the terms. That's how you know in this case. And therefore, a change of domicilium, where it's not the lender but the heirs, that in combination with the Yush has meant that they're entitled to keep the money. Okay, and even more than that, it could be argued that the Torah says you have to give it back. You can't charge interest. But it's very difficult to know, and maybe one or two opinions would turn around and say, because you agreed to it, you have to pay it. Otherwise, you had the choice. And therefore, even though it wasn't ethical, you signed to it and your ush has taken place, and the money has changed domicilium only in a case where the lender, because your ush on its own wouldn't make a legal case for the borrower. Your ush in combination with the change of domain, which would mean it would have to go from the loan shark to a third party, which would be his heir, his children, and it would be when he died. Now, who opposed that view, guys, of Rami Bava Kamma, that does not treat the domain of an heir who inherits the money as the same as the domain of the purchaser? Who has the opposing opinion and why?
Not Rabbi, isn't it?
Excellent, Gavin. You see, you're on top of your game, China.
No, I'm not. It was a bit of a guess. It was a calculated guess, but it was about 65% in my favor. That's all.
Okay, so why does Rava say that that's not the fact?
He says it's not a change of domain because it's in the same family.
Excellent. That's exactly it. Because if it's in the same family, it might be a different address, but it's within the family's asset gain. And we said the example that if Kevin, once he went back to Israel, I dropped something off at his father wouldn't steal it. His father would make sure it went back to Kevin and Ramat Gan. So therefore, a change of domain doesn't mean a loss of attachment of that asset in this case, even if it is a different address. So that's perfect. So in fact, according to Rava, the domain of an heir is not similar to the domain of a purchaser. But here we learn, yet the lender's heirs need not return the investment payments because it's different here. So even here, Rava would agree with regards to a loan shark compared to a robber. Interesting, right? And there's a certain reason. Because the verse states, do not take from him interest and increase, but fear your God so that your brother may live with you. And the end of the verse commands, return the interest to the borrower so that he may live with you. So obviously in that verse, the merciful one instructs only the lender to return the interest. The merciful one does not instruct his son or heirs to do so. Because in view of the fact that interest is given willingly by the borrower to the lender, it becomes the lender's property, even if there's no Yush on the part of the borrower. Why? Because under regular monetary law, the lender would not be obligated to return the interest. So in other words, he contractually agreed, the borrower, to it. The only reason he has to return it is from an ethical point of view, but he's not doing anything illegal. It's consent from both parties. But that's in contrast to robbery, where the stolen object remains the property of the owner and monetary law demands its return. So in other words, because there was no agreement to have it extracted from them, because there's no benefit, whereas the borrower did get the benefit of the money. The only reason the interest must be returned is that the Torah commanded the lender to do so. So guys, since this commandment was addressed specifically to the lender and not his heirs, it emerges that the heirs have no obligation whatsoever to refund the interest that was paid to their father. So even Rava agrees with this particular case. So the Gemara now contrasts the two versions of Rami Bava Kamma's teaching. So what did we learn before? The one who teaches Rami Bava Kamma's statement in reference to the Bryce about interest maintains that it certainly applies to our Mishnah about theft, meaning if you're looking at the plain meaning of the Mishnah's text without the changes proposed by Rava, it's basically that the robber's heirs need not return the stolen article even if it exists. Okay? Because the only possible explanation for that ruling is that they acquired the article by means of Yush and a change of domain. So our Mishnah proves that inheritance constitutes a change of domain. Okay? Now, so what we're learning here is that Rami Bar Kamma says across the board that in both cases, it's very straightforward. Heirs are seen as purchasers when they inherit the money. It's a change of a domain with Yu'ush, a despair of recovering it. Those two factors together make sure that whether it's a case of robbery or interest, either way, the children don't have to give it back because they've acquired it through Yu'ush and a change of domain. But there's a separate opinion of one who teaches Rami Bar Kamma's statement in reference to our Mishnah, and it applies only to the Mishnah with respect to the Brisa. And what does that mean? Is that Rami Bar Kamma might teach it in the same manner as Rava. So what does that mean? So Rami Bar Kamma could actually in essence agree with Rava's position that no proof can be derived from the Brisa because there's a different reason, guys, that applies here. So that the Torah commands only the lender and not his heirs to return the interest. But according to that reason, the lender himself acquires the interest and his heirs acquired it from him regardless of whether inheritance is considered a change of domain. So according to the other reason is that he legally agreed to it because he got the money. He also got a benefit, whereas in robbery, he would never have agreed to it because he got no benefit. Do you get what I'm saying? So according to Rami Bar Kamma's second opinion, it's certainly a non-issue either way. And he might agree with Rava that in the case of a lender, it's very different to a case of a robber. Okay, Kevin, you were going to ask me something. You're going to ask me something?
Oh, picking something up, picked something up from the floor.
Oh, no problem. So, guys, the Gemara starts another brisa that discusses the obligation of a robber's children who receive property that he stole. Now we're back to theft. The rabbis taught in a brisa, if one robs something and feeds it to his children, they are not liable to pay the owner for it, since the object is not in existence. They consumed it. Now, Rav Chisda would limit the ruling to where they consumed the item only after the owner reached the stage of Yu'ush, acceptance of the situation. Okay. If it left, if the robber left it before them intact as an inheritance, okay, meaning they haven't eaten it yet, if the heirs are adults, they are liable to pay, because Rami Bar Kamma, who maintains that inheritance constitutes a change of domain, they must qualify that Bryce's ruling as obviously paying only before this case of Yu'ush. And if it's intact, in other words, they have to return it. Otherwise, the heirs would acquire the article through the combination of Yu'ush and a change of domain. So you'll notice that we keep having to look at Rav Chisda, Rami Bar Kamma, and Rava and see how all of these would equate and sit well with them. So, if one robs something and feeds it to his children, they're not liable to pay the owner for it. If the robber left it before them intact as an inheritance, if they're adults, they are liable to pay. Okay. Now, if they are minors, they are not liable to pay. Okay. Because you need the court's authorization to collect it. But in a case where the adult heirs said, we do not know the reckoning that our father made with you, they are not liable. So what's this a case? Is they don't know if that after stealing the article, the father might have come to terms with the victim and paid him back. So the family is saying, because we don't know, we know that our father stole the item, but we don't know if he came to terms with you and paid you for it. And therefore, why do we have to pay it again? And in that case, they're not liable. Okay, now there's a bit of a problem with this. Why? Well, quite simple.
The loophole.
It's because exactly as Gavin said, everybody would use this loophole. We don't really know what happened. Did he pay you back? Did he not? So, I'll give it to you like this. There's a dispute as to whether the defendant is liable to play this game or not. because there's the plaintiff and he's suing the defendant and he makes this definite claim. He says, listen, this is the amount of money you owe me. And the defendant isn't sure. In other words, he says, I don't know whether I owe you this or not. He's not sure. And the dispute applies only when the defendant is actually unsure whether he was obligated in the first place. In other words, saying, I don't know if I did borrow any money from you. But guys, if he admits that he was subject to the obligation and claims only that he doesn't know whether it was met or not. In other words, he says, listen, I do know that I borrowed money from you, but I don't remember whether I paid you back or not. In that case, he's liable. Why? Because he's admitted to the fact that he did borrow at a certain point. Now, if you look at our case, the heirs agree that the father robbed the article, right? The only doubt is whether he paid for it. So according to all opinions, the plaintiff's definite claim should override their uncertain claim as to whether or not the father paid back. So we can say, how can they use this as their trump card? They've agreed that the father robbed. So it's not like they're saying we don't know if he robbed or not. They said, yes, we know he robbed you, we just don't know if he paid back. So that's basically the issue. Okay? So the Gemara explains the brisa. So Rava said that in the case of adult heirs who say, we know the reckoning that our father made from you, and nothing whatsoever remains for you in his possession. The reason that they're not liable is quite simple, that just hang on one sec, you can leave it outside because I'm teaching. It's probably listening. So guys, the ruling is problematic only according to two opinions, Rav Chisda and Rami Bava Kamma. Why? Do you know?
Just repeat the question. We are listening. Just sorry, my phone actually went beep beep and I couldn't hear what you said.
Okay.
You said something about what? Just repeat it.
So we're not talking about a case where they know their father robbed and they don't know if he paid back or not, because clearly if they admit to the robbery, as to whether or not the father paid back or not, all opinions would say the defendant's liable. It's only if they come across and say, well, their father never robbed at all, and then the plaintiff has to bring evidence. But short of that, if they say we did rob, but we don't know if he paid you back, that's not suffice. That doesn't suffice unless they've got evidence that he paid. So in this particular case, you can interpret the verse as saying, we know he paid you back. We actually know he paid you back. And then they have to prove it. They have to prove it. Otherwise, we don't believe it. They have to have evidence. So that's how the Gemara explains it. So there's another brisa that deals with the situation. If it was taught in another brisa, if one robs something and feeds it to his children, they are not liable to pay the owner for it. Okay? So in the view of Rav Chisda, they are exempt only if they consume the item after the owner reached the stage of Yeush, acceptance of not getting it back, according to the Rashba. According to Rami Bava Kamma, they would be exempt even if they ate it before Yeush, because it's already consumed and they're third party, and they're considered to be a party once removed, and it's not in existence anymore. So if the robber left it before them intact as an inheritance and they consumed it, whether they're adults or minors, they are liable. In other words, this ruling, guys, is problematic to both Rav Chisda and Rami Bava Kamma. Why? Rav Chisda's opinion, the only reason the heirs would be liable is if they consumed the article before Yeush. But because this first clause indicates that the brisa speaks of a situation after Yeush, there's certainly a case where they wouldn't be liable. Just hang on a sec, guys. Can you hear background noise?
No, not at all.
I hear my background noise, yeah.
All right. So let me just
So, Damon, the issue at hand is if there's admittance or knowledge, then it has to be paid back. It has to be paid back to the owner. If they, obviously, minors don't know anything. If they're small kids and they were the inheritors, the food or the offering that they consumed, they wouldn't know any of those facts.
No. So what we're saying is that there's three different things going on. The one thing is whether minor inheritors are liable compared to legal adults who inherited. The other factor is a case where does inheritance after Yush indicate that basically with Yush and a change of domain, it now becomes not liable to return because of those two factors, or is inheritance seem like almost not a change of domain because it's within the same family? So that's the argument with Rami Bava Kamma and Rava, who says that a family, even with a change of domain, is still the same family, and it's not seen as purchases. Then you've got this other issue about the father's honor. And we had that other issue before about if there was fixed property when the robber committed that act during the father's lifetime, that property became mortgaged for the debt. So if the article was consumed, you can take it from the real property. And then there was the other factor that Yush automatically takes place when you've got a lender and a borrower, because in order to get the money, he has to agree to the interest. That's already Yush. He's given up being able to sue for the interest. It might not be moral, and the lender is transgressing a Torah prohibition, but certainly that aspect of Yush is there. But the lender has to pay it back because he can't live with his brother and allow such a thing to happen, being economically damaged. However, that Yush has taken place, but a change of domain is not. So when the children have inherited it from the lender, they, according to Rami Bava Kamma, Yush has taken place with a change of domain for the inheritors. And according to Rava, there's not a problem with regards so much with the lender and the borrower as there is robbery, because there was never consent in any way. And the pasuk says the lender doesn't make any mention of the heirs having to return the interest. So that's all of it in a nutshell. The last week.
Yeah.
All right, guys, we can end at this point. Arthur, just come back on the camera. I want to see you, want to miss you.
Damon, Motzei Shabbos. I might be going to this function. Can we? Let me just check. How much time do we have? So let's check what time Shabbos comes out in Joburg and what time Shabbos comes out here.
Do you want to do it on Sunday
check
rather than Saturday night?
Yeah, we can do that.
No, do it Saturday night, but let's just check. Shabbat.
Actually, Sunday is better for me because I finish work at like 1:30. So anytime on Sunday after, I mean, it's rainy time. So anytime after 1:30 South African time, I'm available.
And we can do it on Sunday.